Today, I'm going to talk you through one of the most vital, most important skills in the legal profession. This is what we call legal research. It is worthy to note at the outset that a lawyer who cannot research law properly is like a doctor who cannot diagnose illness. Courts depend on legal research. Judges write judgments through legal research. Legislators draft laws through research. Academics publish through research. Even legal opinions given to clients are products of research. By the end of this masterclass, you should be able to 1. Understand what legal research truly means. 2. Identify legal issues. 3. Locate relevant legal authorities. 4. Distinguish binding law from persuasive law. And 5. Use statutes, cases, textbooks, journals, and online databases. 6. Conduct Nigerian, UK, and international legal research. 7. Write legal arguments professionally. And 8. Independently handle almost any legal research assignment. At this juncture, I say welcome to your first complete legal research masterclass on the internet. Part 1, what is legal research? I can safely and expressly say that legal research is the systematic process of identifying a legal issue, finding the relevant law, interpreting the law, applying the law to facts, and arriving at a legal conclusion in simple terms. In other words, legal research means finding out what the law says about the problem. Part 2, the foundation of all legal research. It is to be noted that every legal research begins with a legal problem. Common legal problems include: A. Can a tenant sue without a written tenancy agreement? B. Is a WhatsApp message admissible in evidence? C. Can a president be sued while in office? D. Is cryptocurrency legal in Nigeria and other parts of the world? E. Can AI-generated contracts be enforced? As a guide, the moment you see a legal problem, your mind must immediately ask the following question: what area of law is involved? That is the first skill of a legal researcher, and it is very relevant and germane. Part 3, identify the area of law. You must classify the legal issue properly and the area of law involved. 1. Murder, criminal law. Breach of agreement, contract law. Divorce, family law. Government powers, constitutional law. Ownership of land, land law. Tax disputes, tax law. Copyright of music, intellectual property law. Online fraud, cyber law. Why is this classification important? It is important because every area of law has different statutes, different courts, different principles, and different precedents. If you misclassify the issue, your research may fail completely and absolutely. Part 4, the sources of law. This is the heart of legal research. That is, you must know where law comes from. Primary sources of law. Primary sources are authoritative law itself, and they include: 1. Constitution, that is the supreme law, the ground norm. Example, the Constitution of the Federal Republic of Nigeria 1999 as amended, UK constitutional principles, US Constitution. Always start constitutional issues from the Constitution. 2. Statutes or legislation. These are laws enacted by legislative bodies. Examples include Companies and Allied Matters Act, Evidence Act, Criminal Code, as well as the Land Use Act. Note that statutes answer many legal questions directly. Case law, judicial decisions. Courts interpret laws through judgments. This is extremely important in common law countries such as Nigeria, United Kingdom, and United States. Judges rely heavily on precedents. International law examples include treaties, conventions, African Charter, United Nations instruments. Secondary sources. These explain the law. Examples include textbooks, journal articles, encyclopedias, commentaries, and legal dictionaries. These are not law by themselves, but they help to explain the law properly. Part 5, the golden rule of legal research. Always start with primary authority. Never begin serious legal research with blogs or random websites. Start from the Constitution, progress to statutes, then decided cases. Only use textbooks and articles for interpretation. Part 6, how to approach a legal research question. Suppose your assignment says, discuss whether electronic evidence is admissible in Nigeria. Your research process should follow these stages. Stage 1, break down the question. Ask, what is electronic evidence? What governs admissibility? Which statute regulates evidence? What have courts said? Now you already know area of law, that is evidence law. Relevant statute, Evidence Act. Need for judicial authorities. Stage 2, identify keywords. Keywords are extremely important. And for the topic above, electronic evidence, digital evidence, admissibility, computer-generated evidence, and Evidence Act are most relevant. Note that keywords help when searching libraries, law reports, databases, as well as Google Scholar. Stage 3, find the relevant statutes. Go directly to the Evidence Act. Search for sections relating to electronic evidence and computer-generated documents. You may find conditions for admissibility, certification requirements, and judicial discretion. Always cite sections properly. For example, Section 84 of the Evidence Act 2011. Stage 4, find cases. Now ask, which cases interpreted Section 85 of the Evidence Act 2011? Search law reports or databases. Cases may explain requirements and exceptions and judicial reasoning. This is where law comes alive. Understanding precedent. This is one of the most important concepts in law. Stare decisis, meaning let decisions stand. Lower courts follow higher courts. Hierarchy matters. In Nigeria, court authority level, Supreme Court is the highest court, Court of Appeal next, High Court lower, A high court must follow Supreme Court's decisions. Ratio decidendi versus obiter dicta. Ratio decidendi, the legal principle upon which the case was decided. This is binding. Obiter dicta, additional comments by the judge. This is persuasive only. You must learn to identify the ratio of a case precisely. Now, part 8, how to read a case properly. Never read cases like novels. They are not novels. Read a case systematically. Step 1, facts. What happened? Look for what happened. Step 2, issues. What legal questions arose? Search for it. Step 3, decision. What did the court hold? Check it. Step 4, reasoning. Why did the court decide what? Why did the court decide that way? Reason it out. Step 5, principle. What legal rule emerged? That principle is what you use in research. Part 9, how to use legal databases. Modern legal research is digital. Important digital bases include Nigerian Law Pavilion and Nigerian Legal Information Institute. UK, you find Westlaw, LexisNexis, and Bailey. Internationally, you have Hen Online and Justo, as well as Google Scholar. You have to search using keywords, case names, statute sections, and subjects. Part 10, how to write legal research properly. Legal research writing must be clear, structured, logical, and supported by authority. The basic structure: 1, introduction. Introduce the issue. 2, definition. Define key concepts. 3, legal framework. Discuss statutes and principles. 4, case analysis. Discuss authorities. 5, application. Apply law to issue. 6, conclusion. Give final opinion. Part 11, citation. Law demands authority. Every argument should be supported by examples. Say, Sections 36 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Donohue versus Stevenson. Aiko versus Pat Baby. Part 12, analytical thinking. Legal research is not copying textbooks. Yes, it is not copying textbooks. You must compare authorities, identify contradictions, criticize judicial reasoning, then suggest reforms. Good legal research shows independent thoughts. Part 13, types of legal research. 1, doctrinal research. That is researching statutes and cases. This is the most common type of legal research. 2, comparative research. Comparing laws of countries. Example, Nigerian privacy law versus UK GDPR framework. 3, historical research. Studying evolution of law. 4, socio-legal research. Examining law's impact on society. Example, effect of cybercrime laws on freedom of speech, or effects of COVID-19 on global economy. Part 14, common mistakes students make. 1, using outdated laws. Always verify current law. Check if it's still good law or not. 2, quoting without understanding. Understand before citing any case or sections of a particular law. 3, depending only on Google. Do not depend on Google. Those who submitted articles or opinions to Google are mostly not seasoned lawyers who know their onions. Use authoritative legal sources. 4. Ignoring recent cases. Do not ignore recent cases because law evolves constantly. 5. Poor issue identification. This destroys every form of legal research quality. Part 15. How great lawyers think during research. Excellent researchers constantly ask, what is the issue? What law governs it? Is there a statute? Is there precedent? Is the precedent binding or persuasive? Has the law changed? Are there conflicting authorities? What policy considerations exist? This mindset separates average students from outstanding lawyers. Part 16. How to research any legal problem. And this is the master formula. Learn it, know it, use it. The legal research formula. Step 1, identify the issue. Step 2, determine area of law. Step 3, extract keywords. Step 4, find statutes. Step 5, find cases. Step 6, read and analyze authorities. Step 7, compare opinions. Step 8, apply law logically. Step 9, research conclusion or reach conclusion. Step 10, cite properly. If you can master these 10 steps, you can research almost anything in law. Part 17, the future of legal research. Modern legal research now involves artificial intelligence, online courts, digital evidence, international databases, cross-border disputes, cyber law, and data protection. The future lawyer must combine traditional legal reasoning with technological research skills. AI may assist research, but critical legal analysis remains human. Final words from me to you. Legal research is not about memorizing hundreds of cases. It's not about knowing where to find law. Understanding legal reasoning, apply authority intelligently. That is legal research. A strong legal research thinks systematically, reads critically, writes logically, argues persuasively. The law library, databases, statutes, and cases are your laboratory. The more you research, the sharper your legal mind becomes. And remember this, if you don't remember anything. The difference between an ordinary lawyer and an exceptional lawyer is often the quality of their legal research. If you enjoyed this video, please do me a favor by liking and leaving a comment, subscribe, and share to encourage the growth of this channel. And unless I can assist further, this is where I bow out. Thank you.